Yes. You are welcome. I am all out. Does anybody have a charger Abraham can borrow? I have my 2 loaners plus a student left behind, but they are all in use. If someone could spare one, that would be awesome. If not, Abraham, this will, of course, be recorded and put up to get those notes later. As I said, today we are shifting to property torts. So previously, if you're wondering, well, what kind of torts were we looking at? Most of these were in the realm of harm to a person, either physically, emotionally, reputationally. Now we are shifting to people's property rather than the people themselves. Here you go, Abraham. Yes, James. When Anna gets back. Yep. In terms of property, we're going to talk about some different varieties of property, but in general, 2 legal protections. One is against people interfering with your exclusive use. And exclusive use just means if something belongs to you, you get to decide who can use it. It's totally up to you. You can let somebody else use your property. But if you do not, then that property is yours and only yours to use. And anybody who interferes with that use is violating your property rights. And we'll have some examples of that can kind of clear up that definition, because I know it's kind of strange sounding. The second part is much more straightforward, and when we think about protections for our property, this is probably the thing we think of first, right? Against somebody stealing or breaking our property. As I said, we'll talk about different varieties of property. 3 types. First is real property, and real property means something very specific. It's not real as opposed to imaginary property or pretend property. Real means that it is either land itself or things that are basically permanently fixed to the land. So things like houses, factories, the land they sit on. Mobile homes are not considered real property. If you, at some point in your life, live in or own a mobile home, your tax bill that you get from your local government will be for personal property. If instead you own a house, you will receive at least one tax bill for real property, and if you say also own a car, you will receive a different tax bill for personal property. Because personal property is stuff that is mobile, and that includes things like a mobile home. And yes, I know you can move a house or a barn. It sometimes happens, but when those things happen, it's a major undertaking and does not change the fact that things like structurally built houses are considered real property. And personal property is, as I said, stuff that can move. It's your car, which obviously moves. And that's typically what we think of in terms of personal property, is that big stuff that the government charges us taxes for. But it is also much less expensive things, clothing, appliances. to any of that stuff. The third category is intellectual property. And this is something that you have made or a person has made with their mind. Maybe music that they have written, books that they have written, something they have invented. Intellectual property is an area of property law that's undergone a ton of changes in my lifetime and is undergoing potentially some very important changes in your lifetime. Now that we have artificial intelligence that can learn from stuff that is the intellectual property of other people and then use that to create new music, write books, works of fiction. AI can write poetry. And it can also be used to invent things. That's raising new questions about intellectual property. Another thing that you should be aware of is the extent to which your government protects and respects your property rights. In that regard, the United States is not at the top of the heap. Now, 14th is not bad in the grand scheme of things, but other countries rank higher. Finland is number 1. And for example, Austria is 10th. And I include those, obviously including Finland as number 1 helps us get some perspective. But the other reason that I put this up here is when Americans think about property rights, they often imagine that our property rights are much more secure than they would be in, say, European countries, where the governments tend to be more intrusive in some regards into people's personal freedoms. But in this case, they are ahead of the United States in protecting those rights. Now we're going to look again at torts against property. We'll start with torts against real property. Remember, that is land or things that are essentially permanently fixed to the land. And one of these is trespass. This can happen in 2 ways. One, someone has come onto your property without your permission. As if you drive around, especially out in the countryside, and you see trees, fence posts, and things with purple painted on them, those are markers to indicate a warning against trespass. You can also be liable for trespass, and this could also be criminal, but again, we're focused on civil law and torts. You can be liable for trespass if you remain on someone's property without permission. So you might have permission when you come onto their property, but then you might lose it. Somebody might ask you to leave. Where I've seen this most recently in the public eye, especially in the news, was during the pandemic when people would show up at places like Target or grocery stores refusing to wear masks, and also then trying to refuse to leave when managers of stores told them that they had to. We're past the pandemic. Let's hope we don't go back to that kind of thing. But you do need to understand, if you are on someone else's property, even if it's a pretty public piece of property where lots of people are coming and going and nobody's asking permission, like a Target or a Walmart, whatever, if you are asked to leave, you need to leave. You have lost your permission to be there, and you could be sued for trespass if you stay. Or they could call the police, and the police would remove you. In cases of trespass, you don't have to cause any physical harm to the property. That's not what makes you liable. What makes you liable is that you being there without permission is a violation of exclusive rights. You're welcome. If you come onto my land without permission, right, I'm the only one who has the right to use that land. If you are also there, then I no longer have exclusive rights. So that's how you have violated them. Another tort against real property is a nuisance. And a nuisance is different. You are being harmed. Your use or enjoyment of your property is being harmed by something that someone else is doing while not actually on your property. But whatever they're doing is causing an unreasonable interference with your exclusive use or enjoyment of your property. So this could be a neighbor who throws loud parties or plays loud music in the middle of the night, or who keeps a bunch of dogs who bark at all hours of the night. One thing to be aware of, if you have a neighbor who throws a really loud party that goes really late once, you might be able to call the police and complain about a violation of local ordinances. Remember, ordinances are local laws about noise, but you're not really going to be able to sue them for nuisance, because for something to be a nuisance, there has to be a pattern of it happening repeatedly. Right? It needs to be a recurring interference. The other thing that you have to keep in mind is some activities that interfere with your use or enjoyment of your property also have some benefit. And so the harm to you and your use and enjoyment of your property must outweigh the benefit of that activity. If you happen to be one of those farmers north of Kansas City who had a farm a long time before there was an airport, then airplanes flying low over your property could be a nuisance. It could interfere with your enjoyment of your property. But there's a good chance that a court would find the benefits of that airport economically to the city in terms of transportation for people who live in the greater Kansas City area. Those benefits outweigh the harm done to you and your enjoyment of your property. If, however, a court is ruling in your favor, that there is harm caused to you in terms of unreasonable interference, and that the harm outweighs any benefit of that activity, then the court could stop that behavior with an injunction. And an injunction is just the order of a court for someone to stop doing something. And you may hear about injunctions in the news during your life. These are not always going to be about nuisances. You could have an injunction that stops a landlord from evicting someone. The court could issue an injunction against some part of the government to tell them to stop doing something. This is sometimes, I've seen this in the case of like law enforcement agencies using tracking devices on people's vehicles, and people have sued. That is a violation, not necessarily of nuisance, but of their privacy and their use of their property, and courts have ordered those law enforcement agencies to stop that kind of tracking. But of course, here we're talking specifically about an injunction to stop a nuisance. Third, and again, this gets to the more obvious things we think about if we imagine torts against property, and that is damage. If somebody breaks out a window in your house, if somebody smashes your mailbox at your house, those things could be considered that kind of property damage, and they would be responsible for it. I'm going to shift now to personal property, which, remember, that's the stuff that moves around, that's mobile. You can either take it with you, or if it's your car, you use it for transportation. These things in legal language, legal documents, are referred to as chattels. And some of you have probably heard the word chattel before, and if you can't remember exactly where, it's probably in a discussion of American slavery before the Civil War, because it was referred to as chattel slavery, where slaves were treated as the legal property, personal mobile property of slave owners. And so that is why we still talk about chattels today. And so torts against your chattels, it could be the obvious things: vandalism, somebody keying your car would be an example of that. There's also conversion, which sounds more innocuous than what it actually is. Conversion is theft. Someone is converting your property to theirs by stealing it. Yes. Here, I want to add a note about what you might or might not be able to prevent someone from committing a personal property tort against you. And here especially would be thinking about instances of conversion. So nonviolent stuff that you can do is always okay. If somebody tries to steal your purse, you can run away with it, and that is, of course, totally fine. You may be able to use some measure of violence also to protect your personal property. The force must be reasonable, which is fuzzy. And it's also being reinterpreted in the eyes of the law. You should generally assume that use of lethal force is never going to be an acceptable or reasonable way of defending chattels. So if someone should try to steal Danica's backpack, Danica, you can probably hit them, right, to try to get them not to take your stuff. Again, this is not legal advice. I'm not a lawyer. I can't say that if you hit them, everything will be fine, because there are things I also might not know about Danica. Danica, it may turn out that you are a master of Krav Maga martial arts, and your fists alone are deadly weapons. Could be. But you might be able to legally get away with that. If someone tries to grab your backpack and you shoot them in the face, you should assume that you're going to be in lots of trouble. That said, as I mentioned just a few moments ago, the legal interpretations and laws that are passed about these kinds of things have changed. So we used to have, well, we still do, but in the state of Missouri and in other states, there's something referred to as castle doctrine, which is the idea that your home is your castle and you can use deadly force to defend yourself within your home. That has been extended out now in our state to also apply to your car. So if you're in your car and someone approaches you, maybe they're attempting a carjacking, the law now gives you wider latitude to use deadly force to defend yourself in that situation, right? And to defend your personal property. But again, that's just in terms of criminal law. Civil law could still be a different scenario. Yeah, Ayla.
So deadly force in a lab is threat of deadly force for them? Like, say somebody can steal your stuff, if you, like, have a weapon on you, like, don't do that, or else I will use deadly force. Is that allowed?
It would depend. And again, I'm not a lawyer, so I can't say, definitively, and even a lawyer wouldn't tell you definitively. But if it's me, what I generally assume is I would only threaten to use deadly force in a situation where I actually could use deadly force. Because let's say if we go back to the Danica backpack snatching scenario, if Danica says, like, stop, when that person's like a step away, or I will shoot you, then that's still threat of deadly force and could be considered an assault in that case. So that's what I would do. I would only threaten to use force in a situation where I could actually use that force reasonably. The other thing that can get you into trouble is, let's say that you are carrying a weapon and it was concealed, but then you draw that weapon, you could be criminally guilty of brandishing, which is seen as a threatening behavior. So I would just always assume don't threaten it if you can't actually do it legally. That's a good question, though. Our third area of property protection is intellectual property. And we protect intellectual property for really very specific reason. And that is we want people to create more intellectual things. That's it. Otherwise, if someone just has a good idea or invents something, if Claire should write an excellent song and then Jess should go perform that song for her own enjoyment in her own house, like, that doesn't really interfere with Claire's enjoyment of that song that she wrote. It just doesn't. But what that could do, if Claire writes a song hoping to record it and sell copies of it to other people, or in the 2024 world we live in, have people listen to that song, she's paid for the streaming royalties, but then somebody else goes and performs that song and gets the royalties for streaming it or selling albums, then Claire loses out, and Claire's like, well, I'm not going to bother writing any other songs. Somebody else will just steal it and make money on it. We protect intellectual property so that Claire can write a song, make money from it, and continue to write songs that people want to listen to and will pay money to hear. And of course, that also applies to inventions. And that's going to lead us to the two categories of intellectual property we're going to talk about. The first actually doesn't apply to songs. Patents apply to inventions. Things like toilet paper, right, with perforations to tear individual sheets and an ability to be dispensed from a roll. And this is an actual image from a patent application for that. Intellectual property, in terms of a patent for an invention, is hard to get. You have to apply for it. The government has to grant you a patent. That's one of Congress's powers. And so we have the United States Patent Office. You must demonstrate that what you have invented is novel. Either it is totally new, all by itself, or it is a novel improvement on an existing invention. If the government does award you a patent, then you have certain monopoly privileges for a specifically defined period of time. And monopoly means that you are the only person that can either sell products using that invention or the only person who can license some other person or other company to produce that invention. And licensing is just renting out your invention to someone else. Which is something you might want to do. Amron might invent something really cool, but Amron might not have a factory to produce it, and so he might license it to, say, the Ford Motor Company to use that invention and pay him royalties in order to produce things that use his invention. So again, think of license as renting out your invention to other people. That's what a lot of inventors do. As I said, patents give you monopoly rights for a set period. Usually, it's about 20 years. You can apply for an extension to your patent. I remember this when I was much, much younger. There was a new allergy medicine. What was new at the time, it was called Claritin. You can buy it now as a generic loratadine at the store. And at the time, my allergies were horrible. Claritin was seen as this kind of new, wonderful allergy drug. The company that produced it had a patent on that drug, and the drug was really expensive. To make you feel better about how expensive it was, they also made the pills really, really huge. It was like swallowing a Mentos whole. As it turns out now, if you go buy loratadine at the store in generic form, the pills are really tiny because you actually don't need that much of the drug. But when you were paying that much for it, I guess they felt like you should get a bigger pill so you felt like you were getting your money's worth. I mentioned Claritin also because the company that produced it tried to get an extension to their patent. And I believe it was denied the first time. I don't think they got any extension on that. The other form of intellectual property would apply to the scenario of Claire's songwriting, but it is different. It is the same only in the sense that it is a monopoly protection, but it is for something that is simply an expression of creativity. Could be a song, could be a poem, could be a novel, right? Or it could be the sportscast that I used to show here. If you watch, for example, a Royals game on TV, at the end of that game, there's going to be a copyright notice from Major League Baseball saying that you can't show parts of the game that you recorded. You can't even describe what happened in the game without written permission from Major League Baseball. What was kind of funny is that somebody had actually just recorded their TV with their phone showing that copyright warning, and it was just the copyright warning. So I put that up, but then apparently Major League Baseball went after them, and that video was pulled down. One of the other things that makes copyright different is you don't have to apply for it. If you really, really want to protect your creative expression, you should file for a copyright with the patent office. But as soon as you have created something, you actually already have copyright protections. The other thing that's different is the period of protection. Copyright lasts for 70 years, for the lifetime of the creator plus at least 70 years. And sometimes these protections can be extended as well. I mean, that was what had happened. There were different laws that extended things out to protect the copyright protections for Mickey Mouse. Of course, that now ran out finally, but that would, gives you some example of copyrights. Otherwise, once that's over, something enters into the public domain, and then can be used by other people. If you're wondering where the exit slip is, I made that go away so we could work a little bit more on the notes. Intellectual property torts result from something called infringement. And infringement, what it looks like, depends on what kind of property law we are talking about. If it's patents, it's either copying someone's invention and producing it, or using their invention without paying them for licensing. Copyright violations involve using or copying someone else's expression without their permission and without paying for it. All right, and we will stop there. This won't give us much to wrap up, but we will wrap that up. For now, you may get up to pack up.